A federal judge is conditionally approving a plan for the maker of the drug OxyContin to dissolve and settle its lawsuits over its role in America's opioid crisis. The Sackler family owned Purdue Pharma. They are set to pay out $4.5 billion to individual victims and governments. The Sacklers would also give up ownership in exchange for immunity from future lawsuits. They would potentially be required to spend up to $10 billion to fight the crisis. More than 500,000 Americans have died from opioids over the past 2 decades. That includes a record 93,000 deaths last year, driven by the spread of fentanyl. Several attorneys general are planning to appeal the decision. Washington State's Attorney General called the deal, quote, insulting to victims of the opioid epidemic who had no voice in these proceedings. Reuters legal reporter Tom Hals joins me now with more. Tom, welcome. Thanks very much for being with us. So it took a judge over 6 hours Wednesday to read this ruling. Walk us through some of what's in it.
So there's obviously, he knows this is going to be appealed. So he really took his time, walked through the overview of the plan, and then went through all of the objections just to make sure that the challenges to this, just to make sure the challenges to this plan are going to have to, make sure he has everything in place for this plan. The plan essentially does this. It takes what's Purdue Pharma today, it puts all of its assets into a nonprofit trust, and that nonprofit trust will carry on. It'll be overseen by the governments that were suing Purdue Pharma for causing the opioid epidemic. The main contentious point of this entire plan was the release. You called it immunity. The judge was upset by that phrase in court yesterday. He kept calling it a release of liability for the Sackler family. In exchange for the release, they're going to contribute about $4.4 billion to the plan. And that will prevent them from being sued from now on. They were already facing thousands of lawsuits. The main ones that were really a threat to them were the ones brought by state attorneys general around the country. What this does is it protects them from being sued in the future, but clearly the litigation is going to continue. Washington, Connecticut, a few of the other attorneys general, I think there's 9 altogether that are opposed to the plan, said they're going to appeal. And the point here that everybody wants to get at is whether the judge is legally allowed to release the claims against the Sacklers. The reason that's contentious is the Sacklers never declared bankruptcy. Purdue did, the Sacklers didn't. Purdue had to open its books up, let the public look at all of its records. The same wasn't exactly true of the Sacklers. The Sacklers did release a lot of records. A lot of those records are available to the public, but it's not the same transparent process that Purdue had to go through. The main legal claims against the Sacklers, as Purdue would argue, were actually Purdue's claims against the Sacklers, claims for basically unjustly enriching themselves, claims for unfairly sort of looting the company and taking out dividends and cash over the years. Since 2007, they've taken out, I think Washington State said it took out about $10 billion. And the way Purdue argued it was that by releasing these claims and taking that contribution from the Sacklers, it was better than trying to litigate all 3,000 lawsuits. That there was no real way to do that, no convincing way to actually know what you get at the end. And the judge was fairly convinced by that. He was also convinced by the fact that that $10 billion the Sacklers have taken in, that money, a lot of it, or some of it anyway, is now overseas, and he pointed out it's going to be very hard to claw that money back. He did say he thought it was I don't know if he said unjust, but he thought it was a bitter result. He thought they should have gotten more money, they being the creditors, should have gotten more money from the Sacklers. But in the end, he just thought the effort to get that money through litigation wasn't worth the time and effort and all the uncertainties that come with litigation. There hasn't been a case actually brought against that actually went to trial against the Sacklers. So we don't really know how these claims would hold up, say, in front of a jury. So that's sort of how the judge viewed it. He saw it as a sort of a fair way of avoiding all these trials and to get what was a reasonable outcome in terms of money from the Sacklers. And now there's going to be an appeals process. And I think the main legal question is whether he actually had the authority to protect the Sacklers from those lawsuits.
So, Tom, I want to make sure I understand. So, Purdue says the bankruptcy plan is worth more than $10 billion, but that $10 billion figure depends on future donations of medications still under development, like overdose reversals and addiction treatment. What happens if those donations do not materialize like Purdue expects?
It's a great point. Purdue says it's a $10 billion plan, but their opponents, again, Washington State's a good example, puts the figure worth far less. And one of the contentions is exactly like you said, what happens if these drugs don't materialize? Although, to be honest, that wasn't really a main point of the bank. There wasn't that much contention around that. The drugs they are developing, they want to develop a generic version of a drug called Suboxone, I believe it's pronounced. And that drug is used to treat people who are addicted. It treats their addiction while at the same time it protects them from overdose. They also want to develop a generic over-the-counter drug that's the equivalent of a drug known as Narcan. That drug is used to counter somebody that's having an overdose. And so, the FDA has already gotten them down the road towards that process. I believe especially the Suboxone generic is pretty far down the road. So it looks like they will have those drugs in development or able to produce them at some point. It is an unusual arrangement, though. The company will also continue to make opioid painkillers. The company will be overseen by attorneys general and others who are suing the company. Kind of the unusual thing about all this is there is a medical need for opioid painkillers. So it's kind of a slightly unusual situation. You're blaming this company for causing this terrible pandemic or epidemic, but at the same time, its product does have real use to people in pain.
Yeah, and you touched on this a moment ago. Tom, where does this case head next with likely appeals?
Like I said, Washington was very clear, so is Connecticut, that they're going to appeal this. I think the main question is it's going to go to the Second Circuit Court of Appeals in New York. And there is some question about whether you can shield a party that's not bankrupt from being sued. They call them third-party releases, and that's what refers to the Sacklers in this case. There's also a question of whether you can use those third-party releases to protect somebody from the police powers of the state. Essentially, that means from a state attorney general enforcing consumer protection laws, enforcing laws against unfair marketing, laws against public nuisance. Those were all the kind of theories that the attorneys general were using to go after Purdue Pharma. It hasn't really been tested in the way that this case presents. And I don't think it's entirely clear how this is going to come out. I think there is some uncertainty how this is going to come out. They did work very hard in mediation to try to bring these attorneys general to the settlement, to get them to sign on and avoid this kind of appeal, but it didn't work. There were 3 rounds of mediation. They started out with, I guess, 24, 25 states opposing, and they wound up with 9. They got close, but they didn't get there. And we're going to find out what the appeals courts think of all this.
It's certainly a case that's generating a lot of interest. Tom Hals for us. Tom, thank you very much.
Thanks for having me.